Assalamualaikum warahmatullahi wabarakatuh. This is part 1 for the Zoom recorded lecture for the topic Contributory Negligence. Let me maximize the slides. Okay. So basically this topic is the new topic after we have completed the discussion for the previous topics on negligence. We covered three important parts of negligence, which were duty of care, breach of duty, and causation. So for today, for this part, we are going to talk about contributory negligence. The slides belong to Dr. Soni, but I have done some editing to the slides. Okay, and this is the outline of the video, okay, this lecture, okay. Basically, the topic for contributory negligence, it will cover definition and then proceed with statutory provision and also the elements. And later, I intend to cover in part 2 of the video, which is agony of the moment and contributory negligence by children. So for part 1, we are going to focus on the three things here, 3 points, definition, statutory provision, and elements. Okay, we go to definition. So basically, for statutory definition, it is provided under section 12, subsection 1 of CLA, Civil Law Act 1956. You can have a look at the actual provision, but for the purpose of the lecture, okay, I have summarized it. So we are going to see the highlights of the provision, the relevant parts of the provision. And then another way of defining contributory negligence is from case law. Okay? For example, if we refer to the case of Ong Ah Long and Dr. S. Underwood, reported in 1983, it is stated in that case, defendant must show plaintiff did not on his own interest take reasonable care of himself, and plaintiff contributed by that want of care, lack of care, to his own injury. So who must prove? Defendant must prove. Prove what? Prove that plaintiff did not take reasonable care, and that's why plaintiff contributed to his own injury. And if we refer to another case law, which is also local case, Kat Kileng and Teresa Bong Chin, 1978, reported in 1978. It was mentioned in that case, contributory negligence is an expression which means negligence materially contributing to the injury. So meaning that here, negligence here is not used in its usual meaning. So negligence, it doesn't mean breach of duty of care, breach of duty whatsoever. Okay? When we talk about negligence under contributory negligence, we focus on the part of the plaintiff rather than defendant. Okay? Whether plaintiff here contributed to his own injury by way of contributory negligence. And this is the summary, okay, from the provision or the relevant part actually from section 12, section 1, Civil Law Act 1956. Basically, it revolves around apportionment of liability, how liability is apportioned, divided. Okay, it is stated here there are 3 important parts. Okay, where any person suffers damage, usually persons here it refers to plaintiff, as the result partly of his own fault and partly of the fault of any other person. So meaning that here the injury which is suffered by the plaintiff is not totally 100% caused by the negligence of the defendant, partly by the plaintiff himself. So a claim in respect of that damage, of that injury, shall not be defeated by reason of the fault of the person suffering the damage. Meaning that here, yes, we can allow the claim. Okay, we can actually consider, okay, what is the portion which has been contributed, okay, which is caused by defendant and caused by the plaintiff. But the damages recoverable in respect thereof shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So what's the effect in terms of damages, okay, monetary compensation? It will be reduced according to the portion of liability. For example, plaintiff was responsible for his injury up to, for example, he contributed 20% of the injury. So the amount payable to him, okay, amount of damages, compensation, So he cannot receive 100% of the compensation because why? He contributed 20% to the injury. So the court will reduce accordingly, okay, up to the extent or portion of the liability on the part of the plaintiff himself. Okay, now we go to the elements. So basically, just now we talk about definition, we talk about statutory definition, and also definition that we take it from case law. Now we go to the elements. So elements, of course, it is slightly simple compared to the long topic that we discussed under negligence. That one on the part of the defendant to be proved by plaintiff. Now, contributory negligence. Okay, now, who has to prove it? Defendant has to prove it. Okay, and who caused this contributory negligence? Plaintiff is the one who caused the contributory negligence. So there are two requirements that the defendant must prove. The first one, foreseeability, and another one, causation. So it's just straightforward, simple one. Okay. Foreseeability, how do we know? We take it from the case of Jones and Leibach Quarries Limited, common law, 1952. What happened was that, this is the summary. Okay. Contributory negligence in respect of riding on a tow bar, that's the picture, okay, tow bar, when truck crashed into from behind. So basically, plaintiff was riding on this, and then suddenly a truck crashed from behind. So the fact that he was riding on that tow bar actually contributed to his own injury. So in this case, Jones and Leibach Quarries here, contributory negligence requires the possibility of harm to oneself. Meaning that here, plaintiff should have foreseen, okay, if he decided to ride this tow bar, okay, on that way, okay, meaning that here, he might cause injury to himself. He exposed himself to the risk of injury. So a person is guilty of contributory negligence if he ought reasonably to have foreseen that if he did not act as a reasonable, prudent man, he might be hurt himself. He might be hurting himself. And he must take into account the possibility of others being careless. Meaning that here, if somebody is careless, that's what happened actually. Somebody was careless. That's why the truck crashed into from behind. So he exposed himself to liability, something which is foreseeable. And elements of causation, we take it from, it is derived from section 12, section 1, civil act, the one that we discussed just now. So from analysis, okay, from that section, so actually it talk about element of causation. The failure, okay, to take care on the part of the plaintiff is the one which caused, okay, which is the causation cause. It's the linkage between injury and then what cause? Okay? Injury and then the real cause. Okay, now we go one by one. The first element, okay, foreseeability. This is the quotation from the judgment by Lord Denning. Okay, Lord Denning here, it is stated here, you can read on your own. We'll try to have some here. Okay, although contributory negligence does not depend on duty of care, obviously, but it does depend on foreseeability. Meaning that here, the most important element is foreseeability. So just as actionable negligence requires the possibility of harm to others, that's the normal case of negligence. Okay? So contributory negligence requires possibility of what? Possibility of harm to oneself. Can you foresee that you might be injured because of your action here? Okay. And the rest, I think we have discussed it. You can have a look later. You can read on your own the judgment here. Now we want to have a look at some of the local cases, okay, on contributory negligence. We have we have a long list of cases, but for the purpose of discussion and syllabus, so we limit our cases to some of the significant cases. Okay, landmark, consider landmark. So we have the case of Fu Kok Fu and Yap Hai Chui, reported in 1972. Summary basis here, actually, plaintiff was liable for contributory negligence because why? He extended his left arm outside the window. So when you are on board of a car, okay, so basically you are not supposed to extend your arm outside the window because why? It exposed yourself to the injury. So because of that, he was liable for contributory negligence, and liability was fixed at 25%, okay? And 75% is on the part of the defendant. In the case of Siti Rohani binti Muhammad Shah and Haji Zainal bin Saifi, reported in 2001, the finding of the court is that, okay, there was no contributory negligence, even though when the accident happened, plaintiff was riding motorcycle without a helmet, okay? And actually plaintiff doesn't have any didn't have any valid license. But all this fact, it doesn't contribute. It doesn't contribute to the injury suffered by the plaintiff. So, I mean, there's no apportionment of liability because why? There's no contributory negligence. Okay, in another case, Lau Kuan Mui and Ramli Benjamin and Government of Malaysia reported in 1984, all reported in MLG activity. Here, the police was sued, okay, and then police was made liable, was held liable for negligence. Apportionment 75%, but the deceased also, okay, liable for contributory negligence. Okay, what's the action of the deceased here? He jumped into the river, okay, because police was about to arrest him, and then he wanted to escape, so he jumped into the river. The fact that he jumped into the river, he contributed to his own death, lah, injury which led to death, basically. So the liability is split as 25%, 75% on the defendant, police, and 25% on the deceased himself. So cannot get the full amount of claim or damages here. So we go on by one, okay? Fu Kok Fu and yeah, Hai Chui. This is a summary of the facts. Now we go to the full facts here. All right. So plaintiff was traveling as a paying passenger. So plaintiff is a passenger, not the driver. Okay. In what? In a motor taxi. Driven by the fourth defendant. So we have many defendants involved. When a motor lorry driven by the second defendant suddenly reversed from a side lane and collided with the near side of the motor taxi. So that's the collision. Accident happened here. And as a result of the impact, the plaintiff, the passenger, was seated in front. So he was in front. He is not at the back seats here. Okay? And he sustained injuries. And this is the most important part. His left arm, the right and left arm, was completely severed, cut, okay, at mid-arm level. And he also suffered a small laceration, a deep cut, okay, or tear in skin or flesh on the left lower eyelid, and contusion on the left eye. Everything on the left, okay, because he's the passenger. He was the passenger. Bruises. So in this case, actually, because you have many defendants involved, there was admission of liability. The first and second defendants admitted liability, but they also argued he claimed for contributory negligence on the part of plaintiffs, okay, subject to the issue of contributory negligence by the plaintiff. So now we want to know, okay, we want to determine whether there was any contributory negligence on the plaintiff because he was the passenger, he was not riding, and there was collision, accident here which caused him injury. And this is the important observation by the judge. The judge name is Muhammad Azmi. He stated, okay, which is relevant, okay, to Malaysian scenario especially. When traveling in a motor car, okay, along a road where traffic is heavy, like in this case, whether as a driver or a passenger, both. Okay, meaning that here responsibility or the duty is imposed on both. A person ought to be conscious that it is extremely dangerous, very, very dangerous, even to rest his arm on the door window or with or without the elbow protruding. So that's the picture. If you are traveling as a driver, as a passenger, you're not supposed to rest your arm like that, in that position. Because why? You are exposing yourself to the injury. What if there is any accident or if there is any careless motorcycle, okay? So the arm might get injured. And then taking into account, this is also the quotation from the judgment. The various police, stupid road users in the city are so common, especially if it is very heavy traffic. Okay? So common nowadays that they ought to be foreseeable. And a prudent man, reasonable man, all of us here, when traveling in such a place in the city, driving in the city, being a passenger in the city, keep both his hand well inside his vehicle. So you don't expose yourself to the risk of the injury. You put your hands inside the vehicle, even though you don't switch on the aircon. But what if you switch on the aircon? So of course you are not supposed to you're not supposed to put your hands basically because the window is not closed. Okay. All right. So that's basically the important part. I mean the highlights of the case. Fu Kok Fu and Yap Hai Chui. Okay. Here as a prudent man, okay, especially in Malaysia, local scenario in city some more, you have to foresee. Okay. If you do this, okay, you might get injured. Okay? If you are not getting injured, it's okay. But the moment it happens, you might be liable for contributory negligence, even though negligence is caused by some other road users. Okay, but then you contributed to your own injury by putting your hands in that position. Okay, that's basically the essence of this case, lah, significance of the case here. Okay, for the case of Siti Rohani, there was no liability for contributory negligence. Do you want to know what happens actually? What's the facts here? Siti Rohani binti Muhammad Shah and Haji Zainal bin Saifi'i 2001. What happened here? The Moore Session Court held that the judgment by Session Court held that the appellants had not proved negligence on the part of the respondents for the collision between accident between motorcycle ridden by the appellants and motor lorry. So it's between motorcycle and lorry driven by the second respondent. And the first appellant actually, he was riding the motorcycle and was traveling along Jalan Tanjung Olak. Okay, whilst the second respondent who was driving the lorry was traveling on the same road but from the opposite direction. So collision like this. Okay? So the collision occurred at a sharp bend of the road, and then there's no eyewitness, there's no CCTV. All right. So it was in a serious dispute on as to how the collision occurred. And here both give contradictory story lah, because they want to maintain that they are not guilty. Who caused the accident actually? And then the court also noted that the first appellant, who was actually how old was the first appellant? Underage, yeah? He was 12 years old. He was riding without a valid license. Of course, you don't have a valid license if you are 12 years old. And then when the case went up to appeal, okay, the court agreed with the appellant's version of the story. Okay, the first appellant's version was consistent or more consistent. So on the balance of probability, whose story should we accept because it's contradicting. Okay, yeah. So the court accepted first appellant's version because why? It is more consistent with the evidence, which was incontestable. So the court accepted the evidence without any contest. So the motorcycle collided into the side, okay, be it rear, wheel or middle section of the lorry. So from the way accident happened, we can actually conclude, oh, so whose story is should be accepted, okay, should be rely on. And the court said it is very clear that riding or driving without a valid license per se is not negligent. I mean, yeah, it is an offense, but that one, it doesn't amount to negligence. That when you ride without valid license, okay, it depends on the way you ride your motorbike, or it depends on the way that you drive, even without license, yeah. So that's why it is stated here. Rather, it is the manner, okay, of the riding or driving and the conduct, okay, or in relation to the road that contribute to the cause of a motor accident or collision. So because sometimes even though without license, you can ride. I mean, according to the, you can ride lawfully. I mean, according to the way you should be riding. So this is what happened here. The fact that the first appellant was riding a motorcycle without a valid driving license, okay, and without a safety helmet, no license, okay, and even with the pillion rider somehow, okay, pillion rider at the back, who did not enter into the cause of the collision. So it doesn't cause the collision. Okay? So the court accepted the story. The collision was actually mainly caused by the lorry rather than the motorcycle. And then the nature of the injury. Okay, the first appellant did not contribute to head injuries as she did not sustain any head injuries. So meaning that here, the head was safe lah, even though without the helmet. And the wearing of a safety helmet will not have reduced her injury. He suffered injuries to other parts of the bodies, okay, not the head here. So doesn't matter wearing or not wearing helmet here because head was intact, head was not injured. So that's basically how the court decided the case. But of course, looking at other laws, okay, from Road Traffic Act whatsoever, so appellant here would be liable to fine whatsoever, whatever statutory punishment. Okay? But as far as this is civil, okay, civil action is concerned, especially on the issue of contributory negligence, so she shouldn't be liable, and she was not liable for contributory negligence. Okay, I think last case for today. Last case for this part of the video. The case is Lau Kwan Moy and Ramli bin Jamil and Government of Malaysia. So what happened here, during the Chinese New Year, okay, the police conducted raids on boats tied up at the Muar River front, okay, where a number of fishermen were gambling. So they were doing some illegal gambling, illegal activities. And majority of the men on the boat jump into the river, looking at, because when the police came in, okay, they wanted to escape. Okay? And the police party lined the bank shouting at them to come up to be taken away. In the year they wanted to escape, they just jumped into the river. And police said, please come up. Okay, we want to arrest you, basically. Okay? So most of them came to shore and were arrested. Okay, but the deceased, he didn't want to be arrested. The deceased was still in the water, and actually maybe he has some difficulty. Not sure whether he was swimming or not, and appeared to be in difficulty. So he was about to, to be drowned. Okay, and at that time, okay, actually there was a passing boat, a passing fishing boat, realizing his distress, and came up to pick him up to save him. Okay? But the approaching boatman was deterred from the act of rescue by a shout from the leader of the police party, okay, warning him not to interfere and pick up the man. Police said, no, you don't do anything. You don't save that man because we want to arrest him. Okay, we instructed him to came to the shore. Okay, and if the boatman still insisted on saving, okay, the disease, all right, he will be arrested. So they can't do anything, okay, to save, all right, or to pick him up. So the fishing boat accordingly pulled away, and the man, okay, struggling in the water, and went down. Okay, and his body, meaning that here he went down when he was drowned. So his body was recovered from the river some hours later. So now, okay, the personal representative of the deceased sued the policeman and government for damages, asking for compensation for the death, basically. And then the court held that the policeman who uttered a threat, okay, ought to have known and foreseen, as any reasonable man would have known and foreseen, that he shouted the threat here, okay, would deter the boatman from accomplishing his act of mercy in going to the aid of the deceased. So it's foreseeable. Okay? If you shout the threat, of course, nobody will try to save the deceased. And the deceased was so stubborn. Okay? He doesn't want to come up to the shore. So now on the part, on the issue of contributory negligence here, the second and seven defendants, all the police here, okay, the police, part of the police party here, were therefore 75% liable. The liability was imposed on 75%. Okay, meaning that here, the deceased contributed 25% to his death lah, basically, because he didn't want to come up to the shore, okay, to be safe or to be arrested. Okay, I think that's all for part one of the recorded lecture for contributory negligence. So I stop share first, and that's it. Okay, we'll continue with part two of the lecture on contributory negligence. Assalamualaikum warahmatullahi wabarakatuh.